Someone make it make sense.
Probably a couple.
Hello, squirrel friends, greetings. So we finally have word on the new trial date. Ever since that hearing with the new judge, Stephen Hippler, I had been checking to see if anything had come out after he's made his decision. Shout out to Idaho Backyard Cam. I'm glad you took some great pictures of Squeaky. That's cute. I haven't been on YouTube yet, apart from doing my own timestamps from the last live stream, so I haven't seen those yet, but awesome. And so lo and behold, here we go. This was just filed yesterday, October 9th, and we have news on all of this. So let me zoom in actually a smidge. Okay. So redacted order governing further criminal proceedings and notice of trial setting. It is hereby ordered as follows. Hereby, any prior scheduling order is hereby vacated. The following schedule will govern the pretrial matters outlined herein and the trial in this case. Voir dire and trial setting. Jury questionnaires will be administered approximately redacted 2025. Voir dire shall commence on July 30th, 2025 at 9 a.m. The jury trial shall commence on August 11th, 2025 and run through November 7th, 2025, inclusive of the penalty phase if necessary. So in other words, this is allowing time for that second portion of the bifurcated trial, the penalty phase, aka sentencing phase, aka if you're Ann Taylor, mitigation phase. So I'm trying to remember, I tallied up the numbers from the hearing that they're estimates, but I remember thinking it was like over 3 months, and that it's like the longest trial that I will have seen personally, like gavel to gavel. Because a lot of these, like I remember thinking like Karen Reed was 9 weeks, but that, there were some weeks where they only were there for 2 half days and stuff like that. So I don't know. If you were to actually make it all full days in court, Monday through Friday, it was probably more like 7 weeks or 6 weeks, which 6 weeks is really more standard. That's what we see in a lot of these trials. Around 6 weeks. So and what does it say here? So August 11th. Yeah, so almost 3 months, right? If you look at August 11th through November 7th. So that's long. That's a long trial. Trial will begin each day at 8:30 a.m. and conclude at approximately 3:30 p.m. My guess is that this is allowing time, as we see in some trials, for matters at the end of the day. That would be my thought. Like again, using Karen Reed as an example, they would be done early, right? But then Judge Bev would just hop off the bench and run away. Whereas in most trials, if they stop court early like that, or dismiss the jury, it's so that then they have time at the end of the day to handle matters. And, and like in some trials, they come in the morning early. And sometimes they come in early and stay late. Great example of that is the Ezra McCandless. I mean, everybody there was so much lengthy housekeeping before the jury got there and after the jury left, and they worked long hours. Okay, with a lunch break of approximately 45 minutes, Monday through Friday. The parties should be aware that some trial weeks may need to be shortened depending on other obligations of the court. Counsel should have sufficient evidence and witnesses ready to go each day to utilize the full day's trial schedule. So we all see this too, right? If they're like, oh, we don't have our witness ready, and it's like, it ended earlier than we thought. And it's like, now there's 30 minutes of wasted time, and then they get yelled at, right? A final pre-trial conference will be held on May 15th, 2025 at 9 a.m. and continue Let me read this again. A final pre-trial conference will be held on May 15th, 2025 at 9 a.m. and continue May 16th, 2025 if necessary. Earlier status conferences may be requested of the court and or initiated by the court. Motions, woohoo! Death penalty motions. The state's responses to the defense motions challenging the death penalty are due October 10th, 2024. Oh my God, that's today. I have been very anxious in a good way, not nervous, anxious, but excited, anxious, waiting for this I haven't seen those yet when I refreshed this morning, but I will keep an eye out because, I covered all of those death penalty motions from the defense. And for anyone who wants to check those out, they're in the playlist. And it was really interesting. I don't know that anyone else really covered those, but I thought it was really interesting. And there was a lot of food for thought, if you will. And also a lot of factual information we learned as well there in terms of just the history of how all this works and the implications of, the jury being involved in that. And part of what they were, one of the motions was have the trial trifurcated, which I think makes a lot of sense. And that's to have, in other words, you'd have the guilt phase, right? Phase 1. Then you would have the penalty / sentencing phase 2. And then the third phase would be the victim impact statements, because the trouble could arise when you've got victim impact statements. So, okay, well, I'll briefly summarize. So one of the things that's really interesting that we learned is that all of the rules of evidence are thrown out the window when it comes to a death penalty case, when it comes to the sentencing phase, which is pretty crazy. So things that couldn't come in as evidence before now can come in. So, for example, your victim impact statements. So, in a regular trial that's not death penalty, right, you'll hear victim impact statements. And, I talked about this quite a bit too with the last episode of the Ezra trial when it came to her sentencing and the victim impact statements, because, the judge is going to be making the decision as to the sentence, right? Whether it's life without parole, life with parole, whatever the case may be. Again, when it's not a death penalty case, the judge is responsible for determining that. Typically, there was an anomaly with the Carly Gregg trial where the jury actually, voted on the sentence, but that must be a Mississippi thing. So anyway, but normally, most of the 99% of the time, from every trial I've seen or heard of, the judge is going to be deciding the sentence unless it's a death penalty case. So, in other words, take any of those trials, for example, that aren't death penalty. You're going to usually hear the victim impact statements, and then the judge is going to announce the sentence, right? What probably has happened, almost certainly has happened, is that the judge will have already kind of weighed it out and looked at all the factors and determined that sentence ahead of time. So it's not like the more emotional the victim impact statements are, the judge is going to make it the sentence longer than it would have been, right? Hopefully. However, one of the things that did come up in these motions is that technically those victim impact statements are now evidence because, again, the rules of evidence are out the window, and technically a judge could consider them in the sentencing. Again, that to me is wild. But all that to say, it's even worse when you've got a death penalty case and the jury is going to be voting on that, because if you've got the jury and they're hearing a lot of this emotional, the emotional testimony of the victim impact statements, and then they're going to be voting on death penalty or not, you can see how that could be problematic. And in my opinion, to me, this is just my personal opinion, it makes so much more sense to have the victim impact statements, regardless of if it's death penalty or not, happen after the sentence. Have the judge or issue the sentence, or if it's death penalty, have the jury, they present the evidence, right? Or, for that phase of the second phase, have the jury then vote on the sentence, right? And the recommendation if it's a death penalty case. And then after the sentence has been decided and ordered and issued, after that, have the victim impact statement. So that way there's no risk of anybody changing a sentence or basing a sentence on that. And part of the reason, again, just briefly to summarize why I feel like that is more fair, is because I feel like it's unfair to victims who don't have family left behind. And a great example is cold cases. When you've got victims of crimes or murders, right? And let's say it's a death penalty case where as happens all the time, right? Where somebody 30, 40 years later, they finally have a suspect and they get a conviction. But, not only, of course, the victim is gone, but the victim's family might be gone, or they might be estranged, can't track them down. And let's say they don't have anyone to speak up on their behalf during the victim impact statements, or maybe it's only one person, versus in some cases where you've got, 10, 20, 30 people lining up. It seems to me unfair then to those victims who don't have people to come in and give impact statements. And to me, their lives are just as valuable, right? So anyway, I talk more about that at length when covering these death penalty motions from the defense, but that's just a little bit of a summary of different issues there, and why I personally am all for a trifurcated trial when it comes to that. And I think that should be the case always, and just my personal opinion. Not that you would have a second phase per se if it's not a death penalty case where there's like more evidence or whatever, but just separate it out in terms of the sentencing happening and then the victim impact statements. And honestly, it's actually better in a lot of ways for the victims' families too, because as we learned, there's sometimes there will still be objections. We saw this in the Ezra McCandless trial, right, where they were giving victim impact statements, and it was gross and disgusting and horrifying. But Miss Fishney would be objecting and interrupting in the middle of it for things. The other consideration is sometimes there's restrictions on length of how long they can speak or whatever, certain things they can or can't say. I mean, so because you're still having to worry about, or consider the rights of the defendant at that point because they haven't been sentenced. Once they've been sentenced, again, this is why I'm like, I think it's better for everybody, because the victims' families and friends, loved ones, there's no concern about people's right. Like, you know what I mean? Like, you can give them all the time, they can say whatever, and there's no concern about it, having an undue effect on the sentence. Okay, enough about that. All right. So a hearing on the motions will be held on November 7th. Awesome. Can't wait for that. I'm really excited to hear that and see what happens. Okay, discovery motions. The last day to file motions to compel regarding any known unresolved issues is November 14th, 2024. And there's a footnote. We'll get to that here in a second. Responses to those motions are due December 6th, 2024. Replies, blah, blah. Okay, hearing on the discovery motions will be held on January 23rd. Yeah, so far for me, the thing I'm most excited about is this regarding the death penalty motions. But yeah, okay. So Rule 12, ICR motions. We know ICR really well. All motions governed by ICR 12, including motions to suppress evidence, are due November 14th. Responses to those motions are due December 6th. Replies are due December 20th. And a hearing, so this hearing will be at the same day, or on the same day as the hearing for the discovery motion. So they'll have this hearing on January 23rd, and they'll cover all this stuff. Any discovery motions and motions governed by our ICR 12. Motions in limine and notices under IRE 404B. So that's the Idaho Rules of Evidence. Motions in limine and similar motions and notices are due by February 10th, 2025. Responses are due by March 3rd. And then they're going to have another hearing on April 3rd, 2025. Okay, discovery and expert disclosures. And remember, this was an issue that came up in that hearing because the defense had one of their experts pass away, and they're like trying to scramble and get it together with a new expert to fill that previous expert's shoes, if you will. Defendant's discovery deadline is January 9th, 2025. Experts, a list of experts the parties intend to call at trial, including a copy of the expert's report consistent with ICR 16b7 and a copy. So here's the thing that matters here, right? Because the what we're looking for is, did he give her any leeway when it comes to the defendant's penalty phase experts? So here's the guilt, and that I believe is the same. That wouldn't have any reason to change. Okay, here's this footnote though. So this was motions to compel. So the footnote says, counsel should not wait until this date to file discovery motions if the issue is ripe prior to the deadline. The court will provide additional response/reply and hearing dates for earlier filed motions. Discovery motions should not be delayed once the issue is known. Trial will not be postponed because of a discovery motion that could have been filed earlier. Yeah, goes without saying, I feel like. Okay, so then here we go. So rebuttal guilt phase experts, state's penalty phase experts, and then the defendant's penalty phase experts, March 31st, 2025. And so I think, I'm trying to remember. So I think he did give them more time on that. Because I believe their deadline was I believe their deadline was in February before. I can look that up. Potentially, well, I guess it would just be referring to the hearing, but yeah, March 31st, I think that was pushed out. And then, like, consequently, right, it makes sense, pushed out the rebuttal penalty phase experts for the state because they need time then to respond with their rebuttal experts. So, and by moving that one, that was one of the main things too. Like, that was actually, of all the different concerns that were raised by the defense at that last hearing, the judge said his biggest concern was this expert. Because again, if you have to extend the deadline for the defense penalty phase experts, then you have to extend the deadline for the rebuttal phase penalty experts, and then that also you'll have to push out the trial. That was one of the big considerations. I think this is the last of all the deadlines. Let's see, April 28th, 2025. But I think also too, there was also the concern about people's like summer vacations and stuff. What did he say? August 11th? Let me just double check this. Yeah, August 11th. So I think that makes sense. So he's still going to maybe run into the issue of people starting school or whatever. But to me, that it wouldn't be as big of an issue as people having summer vacation. And not only that, but not having anyone to watch their kids who are out of school. Like, to me, it's like if your kids are in school, that you could see how maybe that's not as much of a problem for the parents. And when the kids are out of school and potentially there's family vacations planned. So that could also be. Okay, so right. We were here. So April 20, 2025. Okay, trial materials. Proposed jury questionnaires shall be simultaneously filed under seal by March 24th. Objections are due, blah, blah. Okay, sealed closed hearing. That sucks. I hate it when we can't see them. Proposed jury instructions and trial briefs shall be filed by April 14th. Proposed exhibit lists shall be filed and exchanged by April 21st. And then there's a footnote here in terms of the Bates number used during discovery. I'll be interested to see what he says here. Actually, let me go ahead and find that footnote. Because we see this in every trial, right? Like Karen Reed is a great example where Judge Bev changed the system. They had it all on lockdown, and then she changed the system, and it caused a whole number of extremely long delays during the trial. And like right now, I'm covering the Casey Anthony trial, and the system there is they have their exhibit number, right, when it's for discovery, and then the method they use is Judge Belvin just has the clerk assign the number and doesn't have the attorneys try to figure it out because it's just a mess whenever they did. So let's take a look at this footnote and see what they're going to be doing here. Exhibits may not generally be described. Exhibits may not be generally described, such as, quote, materials disclosed in discovery or at crime scene photos. Okay, so that's not what I thought the footnote was going to be about, how they're going to deal with it getting, submitted into evidence and published to the jury, and then that, number changes, but instead it's just saying you have to be specific. So, okay. Copies of exhibits shall be exchanged by April 21st. Each exhibit must be, okay, well, here we go. Keep reading, Chelsea. Each exhibit must be affixed with an exhibit number. State shall use red exhibit stickers, defense S1 and D1. And actually, I think that's also the same system they used with Ezra in that trial. To expedite trial, yay, here we go. Each exhibit should be viewed by opposing counsel prior to trial and a determination made as to whether an objection will be lodged against the exhibit and the basis for the objection identified. Yeah, that's standard procedure. On or before May 14, 2025, parties shall jointly file a log spreadsheet identifying which exhibits are objected to and the basis of the objection and those to which there is no objection. Guilt phase lay witness lists shall be filed under seal by April 21st. Penalty phase lay witness lists shall be filed under seal. So that's interesting because this, depending on what happens, right, we're going to see the state's response and they're going to have that hearing on the death penalty motions. If they do trifurcate it, that, I mean, I don't know. I guess the date probably wouldn't change, but technically those victim impact statements would no longer be in the penalty phase. The list of witnesses oh, I did that thing again where I autocorrect for them. I always do that. it says the list of witnesses, it should say witnesses, must identify specific individuals and not merely identify groups of people generally. Yeah, I mean, obviously. It is so ordered. There it is, Stephen Hippler. I misjudged Judge's signature. I misjudged Judge in general. And my thumbnail is lacking because, you know, I always, as y'all know, if you've been here before, I always, for these thumbnails, I use shots from this the specific trial, right? Like I don't just like look up their regular, you know, the pictures on their website or whatever. I save for every trial I've covered. This is true. Like where I take a still shot of like from a hearing or from a day in trial or whatever, and I use that specifically. So I don't just use like a stock photo of people that are going to be in the thumbnail. So it's tough because with Judge Hippler, that hearing that we've only had the one, the way the camera is where he's sitting and with the Zoom setup they have or whatever, it's terrible. Like I tried like probably 10 different ones from different points in the hearing of him to try and put him in the thumbnail. And I tried to like make it clear and edit it to make, but he's so like washed out from the lighting. Anyway, it's just terrible. Like it looks awful. So that's why there's no Judge right now in the thumbnail because I had to get rid of Judge. And so I'm hoping that, you know, with like the next hearing with Judge Hippler, maybe, you know, things will be different and, you know, I can get a better shot of him and then he'll be in the thumbnail. But anyway, that's why there's no Judge right now in the thumbnail. So we do have Spicy Santa in the thumbnail with his hat. But anyway, so that's it. And let me just in case, let me check and see if indeed there is anything new from the state because today is that deadline for their responses. Oh, that's weird. Hang on. Huh, Chad Daybell's gone off of the Idaho Cases of Interest website. Interesting. Huh. Unless they just moved the order. But anyway, okay. So by the way, Lori Vallow has been granted a third extension of time for her appellant brief. Okay, so no. So far, nothing new yet in terms of the response from the state on those motions regarding the death penalty. So I'll keep an eye out for that. And as soon as that pops up, I will be sure to cover that either live or in a video. But that is it for this one. And hopefully everybody's caught up to speed now. Again, if you're interested in learning more about those motions regarding the death penalty, since that will be coming up, right? Like when we get the state's response, and then they're going to have that hearing. And whenever I cover the state's response, it might be worth it too for me to pull some of those defense's motions up as well, you know, so we can kind of go through it one by one, like the defenses. Actually, that's a good idea, thinking out loud here. Like the defenses, because there were a lot of motions, okay? I think there were like 8, maybe more. But, you know, so for each one, there's going to be a separate response, so equal numbers. So pull it up from the defense, kind of go over it, maybe not quite as in depth as we already have, but just kind of go over it a little bit and then look at the state's response. That might make a lot of sense. So I think I will be doing that. It's a good plan. So anyhow, that's it for this one, guys. For anyone who missed the stream last night, I'm working on the timestamps for the latest episode in the Casey Anthony trial. I've got a good portion of them done, but I'm still finishing that. But should have that finished soon. And then I believe I have the next episode scheduled for tomorrow. So anyway, thanks for being here, being a squirrel. Y'all are awesome. And I'll see you guys very shortly, either with an update for the state's response, or if not then tomorrow for the next episode of Florida versus Casey Anthony. Did the jury get it wrong? All right. See y'all then. Bye.